Good morning to all of you. Today we are going to discuss a case law on section 167 clause 2 CrPC. According to the above section, the magistrate can give a remand to a person up to 90 days in certain cases and up to 60 days in certain cases, in which period the police are supposed to file the charge sheet. If the police cannot file the charge sheet within the stipulated period of 90 days or 60 days whatsoever, then the court shall release him on bail, shall release the accused person on bail, and this is an indefeasible right. That means the court shall release him on bail provided he is able to furnish sureties to the satisfaction of the court. So this is the basic law. Now, the court held that COVID-19 cannot be an excuse for filing the charge sheet for not filing the charge sheet within the stipulated time. So it cannot be an excuse under section 167 clause 2 CrPC. This was held by Bombay High Court bench at Nagpur in while disposing the criminal appeal 344 by 20 on 7th July 2020 in the famous case of Suchit Arun Kumar Rahulkar versus the state of Maharashtra by single judge bench Honorable Justice Vinay Joshi. So he held that even in this pandemic period, the limitation cannot be extended for criminal cases. According to section 167 clause 2, the charge sheet should be filed within the time limit. Now we are going to discuss the details, how it happened and what are the submissions on behalf of the police and how it was negated. All these things we are going to discuss. Briefly to start with, this is a case relating to the rape on a minor girl. So on 31/2020, that is January 30th, a minor girl aged about 17, she gave a report in Gondia City Police Station that here the petitioner means the accused, actually he should be called as accused since this case is Suchit Arun Kumar Rahulkar, he is the petitioner, right? This petitioner, he and two others, he committed a rape or sexually assaulted the victim, and as such, basing our complaint, a case under sections 376 and 376 clause 2 IPC as well as section 4 and 6 of the POCSO Act was registered against these people. POCSO Act means Prevention of Children from the Sexual Offences Act. So I have told you, aggravated sexual penetrative act, sexual penetration, all these things we have discussed in that. So consequently, the petitioner, that means the accused, was arrested on the same day, on 31/20, and he sent for remand, right? So he was in judicial custody. Now, according to section 167 clause 2, since he was produced on 31/2020, so since it is a case of grave nature, 376, the charge sheet should be filed within 90 days. That period will they expire by 34/20. So April 30th, before 30th of April, they have to file the charge sheet. That is the legal position, right? If charge sheet is not filed, definitely this petitioner has got a indefeasible right to get, or statutory right to get bail, right? So here the point is, he has filed a petition before the Honorable High Court stating that the police did not file the charge sheet by 34/20 and they filed the charge sheet on 4/5/20. Therefore, he should be given the regular bail or statutory bail. And but the Honorable Court at District Court did not grant him bail. Therefore, he has approached the High Court, right? Here what happened is, the special judge or the judge, district level court, he has stated that due to the pandemic COVID-19, the Supreme Court in Sumoto WP number 3 by 2020 and the circular dated 16/3/2020, it stated that the period of limitation extends. It stands automatically. It is already extended because of the COVID-19. The police may not be in a position to file the charge sheet. Right? So, taking the WP number 3 by 2020 into consideration, the Honorable Trial Court, so they have dismissed the bail petition. Right? So, why? Because even though after 30/4/2020 they filed the charge sheet with a delay of 4 days, yes, it is accepted. So it is stated that they have filed the charge sheet within the time frame. So if they file the charge sheet within the time frame, there is no question of indefeasible right for this person to get bail. Right? Now the petitioner says, already as told you, says that the police failed to file the charge sheet within the stipulated period and therefore is entitled to get bail, and this writ petition WP 3 by 2020 does not come his way because it is a general order, it is a general circular, it is with the intention of helping the people in civil cases who could not file the cases within the time and whose stay orders can be extended but not for criminal cases. That is his contention. But APP, so on behalf of the state, the APP said that yes, the police have already completed the investigation. In fact, they brought the charge sheet to the court on 26/3 and 27/3 and also 1/4. So actually, they have to file the charge sheet by 34, right? 34, I think, yes, by 34. Okay, but still, so on 26/3, 27/3 and 1/4, but it was refused because of the pandemic situation. No person is allowed to come into the court, and anything is there, they have to fight only e-filing. That too, e-filing is allowed for bail petitions or urgent matters. That's all, not for these routine things like charge sheet. So actually, they tried to file the charge sheet, but it was not taken on file by the court. Now, they are not responsible. Hence, there is no fault on the prosecution side. So now, taking this advantage, the benefit should not go to the accused or the petitioner. Right? So now, since the accused is the petitioner is an accused in crime number 49 by 20 of Gondia City. So now he is requesting for the inherent jurisdiction of the court under section 482. That is, quash the order of the trial court. Right? He has got a right to get the default bail. So this is an indefeasible right which is resting in his favor. Right? Now there are 2 points to be decided by the Honorable High Court. Number 1, whether the directions given in the WP number 3 by 20 of the Supreme Court is applicable to this criminal case or not. 100% no, because they have clearly stated, it is not clearly mentioned in the Supreme Court circular dated 16/3/2020 or in WP that the extension will be for criminal cases. Right? It is a general circular issued for extension of the limitation period, not for this. So second point is whether the police attempted to tender the charge sheet within the period of time, that is whether they have complied with or section 167 clause 2 CrPC or not. Right? So previously Madras High Court in the certain case of Madras Supreme Court has clearly stated, in case of S. Kani versus State through the Circle Inspector of Samaya Nallur Police Station, right, in criminal appeal number 452 by 20 dated 19/6/20, the Supreme Court stated that WP 3 by 20 would not take away the indefeasible right of the accused to get default bail for non-submission of the charge sheet within the prescribed time. Right? Because 167, it is a fundamental right relating to or protection of personal liberty. No person should be unnecessarily subjected to jail. Right. And another case also. In case of Uday Mohanlal Acharya versus State of Maharashtra 2001, yes, it was ruled that the accused has got indefeasible right under section 167 clause 2 CrPC. The circular did not specifically speak of section 167 CrPC. So that means it is a general circular, it does not have any say in this particular aspect. Right? So as regards the submission of the charge sheet by police, so they say that, of course, the court normally, the trial court or the court in which they filed the charge sheet, they will say that the charge sheet was filed only on that particular date, on 1/4 or something like that. Now it is dated as 4/5/2020. Here the court says whether the police filed it or not, it's a different thing, but as per record, since it is filed on 4/5/20 and you are under the impression that the limitation period is there, that means we have to take into consideration that the charge sheet was not filed within time, because he has depended upon two more important things. The remand report, 15 days. The remand reports dated 27/3 and also 23/4. 27/3, 2020 and 23/4, April 23rd. They say that the investigation is still going on. Normally, police write letter, remand extension report, the investigation not completed, therefore request that the court may extend the remand. Like that, they would have routinely written. It was taken into consideration by the court, and the efforts made by the police on those particular days, even though they go to the court finished, they were not taking into consideration. Ultimately, the accused got bail. Right. In 2018 also, there is a similar case by Justice Uday Umesh Lalit. So in the case of Achpal versus Ram Swaroop and another versus State of Rajasthan. Right. In this case, it was decided on 24/9/2018. Right. Here, the charge sheet was filed on the particular day. Right, before the statutory limitation period. But what happened is it was returned due to some technical defects. So even though it was returned due to technical defects, it is deemed that no charge sheet is filed. This is the problem. So not many cases you will be hearing. So when we worked as police officers, there is a famous case in Karanchedi incident, Chaganti Naidama versus State of AP. Actually, we filed the charge sheet on the 90th day, but the court considered it as 91st day and given bail. Of course, that magistrate was suspended also because of the negligence. He has not considered our view. Actually, that was 90th day. He has counted the day of production of the accused. It is a different thing. When time comes, I will tell you. But what happens is why 26/3, 27/3, 1/4 were not in consideration. That's why there is a riffle between the police and court staff also. So whenever the police file a charge sheet, the court staff are destined, they have to give a number, CSR, charge sheet register number, which they don't give. Due to that only, now even though police says 26/3, 27/4, there is no evidence for that. The only evidence is remand report that they have extended. So it happened in my case also. I want to tell you, it will take 1 minute or 2 minutes. So express FIR has to be sent to the magistrate. So the constable went to the magistrate around 9:30 p.m. By the time the magistrate is going to maybe along with his family, of course he saluted the magistrate. Magistrate said, "What matter? No, sir, you please come back after the cinema. I will get your signature." Okay, he has gone. He has returned around 12:45 or so. At that time, the constable went. The magistrate put the date and time as 00:45. Then he said, "No, Your Honor, we have come already at 9:30 p.m. But because you are in a hurry," then he said, No. Whenever I receive the FIR, I will put that date. Because of that date, our case has gone. Because whatever, that's why the sanctity of a magistrate, sanctity of the judiciary is more important. They will have given much credence also. We can't help. Here, the magistrate, since he put 00:45, it was taken as absolute truth. We cannot say, even though the constable went at 9:30, it's gone. So please remember, these are the practical incidents which you have to know. Right? Anyway, this is a good case. Thank you very much.